Hello, everyone. I am delighted to welcome you to tonight's seminar with His Honorable Judge Benjamin Gumpert, QC. My name is Yulia Nuzban, and I will be moderating this event. In his presentation, Ben will discuss the practice of jury trials in common law countries, with a special focus on the UK, which is his home jurisdiction. Ben will speak for about 35 minutes. At the end, Ben will be taking questions from the audience, and so I invite you all to send me your questions using the chat function. I will read out the questions that you have during the Q&A session, and we have reserved about 20 minutes for that. Before we start the seminar, allow me to briefly introduce the speaker. His Honorable Judge Benjamin Gumpert, QC, is a seasoned criminal lawyer and trainer from London. He has more than 30 years of practical experience in criminal trials as a prosecutor, defense lawyer, and judge. Now, for those who don't know, QC stands for Queen's Counsel, and it is a mark of quality and recognition in the UK legal profession. Between 2015 and 2020, I had the pleasure to work with Ben on a daily basis when he was leading the prosecution team in the ongoing case at the International Criminal Court. He left the ICC a few months ago to become a full-time judge in the UK. Without further ado, I'm giving the floor to Ben.
Thank you very much, Yulia. And can I just check with you as a model participant that you can hear what I'm saying? Excellent. So I'm going to talk briefly this evening about the jury system as it works in England and Wales. You may be aware that so far as the legal system is concerned, the United Kingdom is not, in fact, a united kingdom. Scotland has a completely different legal system, and Northern Ireland likewise. The jurisdiction I'm speaking to you about is the jurisdiction in England and Wales. That's the jurisdiction in which I have practiced before I went to the International Criminal Court, and in which I practice again now as a judge. So I want briefly to explain to you how the jury system actually works in England and Wales. And then I want to discuss some of the issues which arise when people attempt to assess the merits of using a jury to decide the facts of a criminal case. It works like this in England. The most serious criminal offences, so homicide, robbery, rape, all conspiracies, which is the way in which organized crime is principally prosecuted, are tried in the upper criminal court, which is called the Crown Court. And where the accused person disputes the charges against them, they will be tried by a judge and by 12 lay people who are the jury. How does a jury get chosen? Well, each Crown Court receives the names of potential jurors selected at random from the electoral roll. That is to say that the people who can elect our politicians and members of parliament are the people who can sit on a jury. Jury service is an obligation. It's not a choice. There are limited exemptions, but principally those are based on health problems. Otherwise, it is an obligation to sit as a juror. Statistics, the most recent I could find were those from 2018, suggest that just 72% of people resident in England between 18 and 34 years of age are registered on the electoral roll. That rises to 85% between 34 and 54 years old, and people who are age 55 or older, that's a mark I passed now a couple of years ago, are 95% registered. Anecdotal evidence suggests that the people who are not registered to vote tend to be people of low educational attainment, people on low incomes, and people with health problems. So I think it's fair to acknowledge right from the start that the pool from which jurors are selected in England and Wales is biased, is a little bit loaded in favor of healthier, wealthier, and better educated citizens. At the beginning of each trial, 12 jurors are selected at random. Now, the trial is presided over by a single judge, and the judge will deal with all of the legal issues which arise in the course of the trial. So, disputes about modes of liability, disputes about the legal ingredients of the crime, disputes about the legal ingredients of the defenses which might apply, insanity, duress, disputes about the admissibility of evidence, and all procedural disputes. Those are decided by the judge alone and decided in the absence of the jury. It's also important to acknowledge that there are limits on the use of the jury system, because the judge has the power to dispense with the jury altogether in exceptional cases. Principally, this power is exercised where there is evidence of what we call jury tampering, or more colloquially, jury nobbling. In other words, where there is evidence that the jury may be bribed or threatened so as to return an improper verdict. If there is evidence that that is a real likelihood before the trial, then the judge has power to proceed on her own without a jury and to make factual determinations herself. And similarly, if it emerges in the course of a trial with a jury, the judge can discharge the jury and proceed on her own. Now, this is something which is vanishingly rare. In 33 years practice in England and Wales, I have never participated in a Crown Court trial without a jury, and actually I don't know any other practitioner who has done so. The judge, as I've said, retains certain powers to do with legal decisions. So what does a jury do? Well, essentially a jury's got three jobs during the course of a trial. One, they have to decide whether they are sure that the accused person, the defendant, is correctly identified as the alleged offender. Two, they have to decide whether the evidence they hear has made them sure that each element of the offence, of the crime charged, has been proved. And three, they have to decide whether any of the elements of potential defences, maybe insanity or duress or self-defence, are proved so that the defendant is excused from a verdict of guilty. Just briefly, how does the trial go down? Well, the prosecution presents its case first. At the end of the prosecution evidence, the defence have the opportunity to argue that there is no case to answer. That is to say that no reasonable jury could possibly come to a guilty verdict. And again, it's the judge alone who will decide a submission of no case to answer. Frankly, the submission of no case is designed as a safeguard against perverse guilty verdicts. Effectively, it's in use only where some part of the prosecution's expected evidence has not emerged, where a witness, for example, hasn't turned up at the trial or has given different evidence, or in cross-examination has been persuaded to change the story which they had initially given. Assuming that submission of to answer is unsuccessful, the case continues, and at the end of the defense evidence, the advocates, first prosecution, then defense, get a chance to make closing speeches to persuade the jury that they should view the case in a particular way. When they have made their speeches, the judge sums the case up. Firstly, the judge will remind the jury of what the evidence was, and will tell the jury that during their deliberations, at any time, they can come back into the court, send the judge a note saying, please will you remind us what the evidence on this or that point was. So the jury don't feel that they have to try to memorize or to take notes which cover every single piece of the evidence. They're given reassurance that they can ask and be reminded of what the evidence is if they are uncertain. Secondly, and equally importantly, the judge will tell the jury what the applicable law is. And the judge will do this orally, will tell the jury in simple language. But in addition, judges in England and Wales now give the jury a written guide to verdict. And this is the only slide that I'm going to put up in the course of this talk. And I hope that that is visible to you all. Again, I just wonder if I can ask Yulia to indicate that she can, as a test rabbit, see what I've put up.
Ben, as a test rabbit, I confirm that I can see clearly.
Good. So you can see that in this case, this is a real case, although are not real names, a case in which I gave written directions to the jury. And you can see that I told the jury they needed to ask themselves 9 questions because it was quite a complicated case. And I won't run through them all, but you can see that it is effectively a 9-point decision tree. Firstly, are they sure that the victim, a man called Jordan Wallace, was actually taken away against his will? If they were sure of that, were they sure that the defendant concerned was involved in that taking away? Question 3, was he acting intentionally? 4, that there was no consent. And as I say, I won't go through to the end. The last 7, 8, and 9 are all questions about possible defenses. In this case, the defense of duress. But what the jury have to do is to proceed in a logical fashion through the 9 questions in this case. And only if they arrive at question number 9 and are sure there that they have arrived at positive answers in respect of all of the legal elements which these questions address, can they arrive at guilty verdicts. Ultimately, the jury is required to arrive at verdicts on which initially all 12 of them are agreed. After a few hours, and it's a period which is not fixed in law, ultimately the judge decides, but the judge will have consulted advocates for the prosecution and the defense. The judge can tell the jury that a majority verdict is now acceptable, on which at least 10 of them are agreed. But if there are 3 dissenters, either guilty or not guilty, either way, then we have what in England we call a hung jury, an undecided jury, and the case will have to be retried in front of a different jury on a later occasion. After the verdict, if it's guilty, jurors play no role at all in the sentencing of the accused person. That is for the judge alone. It's true that the law in England and Wales permits a jury to make a recommendation of mercy, but that again is a very rare event. And again, in the 150 odd trials which I have taken part in over the last 30 years, it's not an event which has ever occurred to me. So that, dear colleagues, is an explanation in brief of how the jury system works in England and Wales. And I want to turn now to some of the controversial questions about juries on which, it seems to me, people have sharply conflicting views. These are matters on which I have views myself, and I shan't hesitate to tell you what they are, but I want you to be clear that even though I am now a judge of the Crown Court in England and Wales, these are not official views, they are my personal views, and some of them may be either simply wrong or views which you disagree with. And I'm hoping in the question and answer session, which will follow this talk, that you will let me know, particularly where you disagree and why you disagree, because that will make for the most interesting discourse in that question and answer session. So I think the first criticism is this: ordinary lay people, bakers, lorry drivers, carers in old people's homes, people like that aren't competent to determine what may be complex factual issues in criminal proceedings. Surely, people say, this should be left to professionals, to people with long experience of deciding what is the truth and what is not. In short, by judges. In particular, critics suggest that juries get confused in long cases, cases which last for weeks or sometimes even months, cases with large quantities of evidence. People think that juries are less able to judge from non-verbal signs whether a witness is being truthful or not. And critics of the jury system suggest that ordinary people, possibly people who have low intelligence, perhaps little formal education, may fail to understand the complex testimony of scientific and medical experts whose evidence can be crucial to determining cases in the Crown Court. Well, I want to say straight out that I don't believe that lawyers or judges, in fact, do have any particular expertise in determining whether a witness is being truthful, although they often think that they do. An interesting study was published in 1991 in a magazine called American Psychologist. It was called Who Can Catch a Liar? And there were 509 persons, psychiatrists, police officers, Secret Service agents, lawyers, judges, college students, and ordinary working adults among those 509 people. And the participants were shown a series of 10 videos of people who were describing their feelings while watching a scene on the television. The participants were told that half of the subjects were lying. Either they hadn't watched the television at all, or the feelings they were describing were false. And at the end of the video, each participant was asked to determine whether or not the person in the video was telling lies or telling the truth. Every single group, the judges, the lawyers, the psychiatrists, managed no better than 50%. In other words, the score that they would have produced had they answered at random. The only exception, the only group of people who as a group were slightly and only slightly better than pure guesswork in determining whether people were lying or not, were the Secret Service agents, which I confess I find slightly disturbing. But there it is. Those were the findings. So are judges better at telling whether witnesses are lying or not? Well, the evidence suggests actually not. Another experiment, took place in the United Kingdom, was designed to test the ability of lay people to make probability inferences from basic statistical data. How much more likely is event A if it is preceded by event B? How much more likely in statistical terms? And the sad truth was that these ordinary people, potential jurors, weren't very good at that kind of statistical analysis, at that kind of structured decision making based upon evidence. But then the researchers performed exactly the same tests using a group of judges. The judges were no better than the ordinary lay people. Their score actually was fractionally less good. There was a large-scale experiment back in the US taking a sample of 167 federal judges. They were asked to make judgments in 5 different types of situations in which people have been shown to make cognitive errors by relying on mental shortcuts, the kind of fallacies which those of us, actually unlike me, who are well-educated are familiar with as the kind of formal fallacies. So perhaps the most obvious example is confirmation bias, where people tend to look for evidence which supports their prejudices. And the judges were no better, again, than laypersons in eliminating these biases, these cognitive judgment errors. Lastly, I could go on with the stats, but I'll stop here. A study of 400 judges in all 50 states of the US tested their understanding of the basic scientific criteria, 2 key criteria for scientific evidence, of falsifiability, whether a proposition is capable of being falsified, because if it isn't, then such a proposition is not very useful in terms of scientific evidence. And secondly, what was meant by error rate, that is to say, on how many occasions when a particular experiment or a particular sequence of actions is undertaken, there will be an error, there will be an erroneous result. Only 4% of the judges were able to describe what falsifiability was. 35% of them gave answers which were unequivocally wrong. And when it came to error rate, it was even worse. Only 3% could explain what error rate was, and 86% gave answers which were completely wrong. So, in short, when judges and other legal professionals are given those same tasks that jurors are asked to perform, they don't do any better. And think of this. Unlike judges who sit alone or in small panels, juries are composed in England and Wales of 12 people, people who can pool their perspectives and insights. And furthermore, juries get structured decision-making aids, like the slide that I put up on the screen, in terms of a decision tree, a series of questions which they are instructed to ask themselves, and which, if they follow those instructions, mean that they will have taken into account the necessary aspects in order to arrive at a structured decision. So for myself, I don't find the criticism that juries as lay people are incompetent on the job of fact-finding to be a persuasive one. Let's try another criticism. The possibility of bias, partisan sympathy may distort jury verdicts, may mean that juries won't do their job properly because they will be swayed perhaps by the popularity or unpopularity of the person who is accused. And I think this is a serious criticism, and it does give rise to serious concern. In England, there have been notorious cases, particularly where popular sports personalities have been accused of crimes, where there's been strong evidence. And on a number of occasions, they have very surprisingly been found not guilty by juries. I would suggest, however, that in a group of 12, even if one or two juries do have an inappropriate bias one way or another, it's likely to be balanced out because this is a relatively big group making a decision. And in fact, in my experience, jurors take their work very seriously, and they are conscious that they may have biases and prejudices on some matters, and conscious of the need to work to put those biases or prejudices aside. Frankly, I don't accept that legal training, legal qualification, the kind of qualifications you need to become a judge will necessarily make a person fairer or better able to see matters about which they have strong feelings more objectively. In fact, I think there's a distinct risk that criminal judges, criminal court judges, working in the criminal justice system every day of their lives can tend to become rather cynical about the excuses, the explanations which accused persons put forward. My feeling is that a jury may be better able in those situations to put themselves into the shoes, into the situation of a person who is accused, and to judge what their state of mind may be in very often very stressful circumstances, which might not occur so very often in the probably rather comfortable middle-class lives of lawyers and judges. Another criticism, well, juries can be influenced, they can be tampered with. The possibility of threats and bribes to members of the jury means that in the most serious cases, in organized crime cases, they can't be trusted. Well, unlike the previous criticism, which I think is a serious and arguable one, I don't think that this is a valid criticism. I don't think that juries are any more susceptible to bribes and threats than judges are. Indeed, I think it's rather harder to bribe or threaten 12 people than it is to bribe or threaten 1 or 3 judges. Jurors are not a known quantity. They appear for the trial and then they go back to their ordinary lives. It's not predictable in advance, unlike with the judge, who the jurors will be. Their addresses aren't known, their workplaces aren't known to the kinds of people who may want to influence the outcome of a trial. And ultimately, as I said to you earlier, if there is a genuine possibility of jury interference, the judge has the power to discharge the jury and continue the trial alone, as she would in the civil law non-jury system. So I've dealt with some of the criticisms which are regularly leveled at a jury system. I want to finish using my last 7 minutes or so by telling you of 2 significant advantages, 2 positive reasons, which in my opinion recommend the jury system to society as an important, as a valuable part of a criminal justice system. The first advantage is this. It's the effect that operating in a jury system has on advocates, lawyers, and on judges. As you know, I've recently come back to England to sit as a full-time judge. For 7 years before that, I worked at the ICC, the International Criminal Court. I don't know whether any of you have very much acquaintance with the jurisprudence, with the judgments of the International Criminal Court. They are frequently impenetrably dense. Judges express their findings on the law and on the facts in highly complex technical language. They approach the matter in a way which is more typical, I think, of academics at university. Every page of the judgment is thickly footnoted. Every possible wrinkle and quibble is chased down. Let's take the case of Jean-Pierre Bemba. The judgment in that case was so long that when printed out single-sided, it was too heavy for one person to carry for any great distance. And 3 years later, that same judgment was overturned. Why? Because, said the appeals chamber, no reasonable bench of judges could have come to those heavyweight conclusions. And the appeals judgment itself didn't weigh very much less. And no ordinary person, frankly, in my opinion, no ordinary lawyer would have been any clearer about concepts such as indirect co-perpetration or command responsibility than they had been before those judgments were written. Perhaps I shouldn't speak for others. I tell you frankly, when I read the parts of those judgments which purported to deal with those legal concepts, I did not feel that I had been enlightened. The jury system enforces on advocates and on judges the need for clear thinking, simplicity, and brevity. Judges have to be able to express the factual and legal concepts involved in a case in a way that 12 ordinary people, 12 people on the jury, will understand. However strong the prosecution case is, if the prosecutor can't explain it in terms that a jury will understand, then the case will be lost. It's a huge advantage, in my opinion. The truth is that most people who appear before the International Criminal Court don't understand the details of the crimes they are accused of. They don't understand the details of the modes of liability by which they are said to be guilty of those crimes. People I know have gone to watch proceedings at the ICC from the public gallery, sometimes not for a few minutes, but for days. And they report back that they haven't understood how what they heard from the witnesses, from the advocates, from the judges, has got anything to do with the case which is being tried. In a jury trial, that will not be the case, I guarantee. The presence of the jury as the ultimate arbiter of the facts of a case imposes on the professionals concerned a discipline which means that they have to make the criminal law comprehensible to the people who are accused and to the people who make up the society for whose benefit the criminal justice system exists in the first place. So that's the first advantage as I see it. But there's a second advantage, which I can express rather more simply, and it's perhaps less concrete, but no less important. It's to do with the makeup of society. I think there is a huge value in a jury system because it places a responsibility on the ordinary citizens who make up that society. If you are chosen to be a juror, you get a letter or an email out of the blue. Come, you must come. Otherwise, the police will arrest you. You must come to the court to sit as a juror. Justice for those people isn't some kind of remote, inscrutable edifice which involves only criminals, lawyers, and judges. It suddenly becomes part of your ordinary, everyday life. And the large majority of citizens in England can expect, at one time or other during their adult, to take on the responsibility of being part, an active part of the justice system, a key part, the part which decides whether a person is guilty or not guilty. And in my opinion, that responsibility promotes a cohesion in society, a togetherness in society, which is highly desirable. So I thank you very much for your attention over the last 35 minutes or so. We've got another 20 minutes of the hour left, and I would be very pleased to answer questions which you may have. And I think that we can click on the chat function. I've just done that, and I can see that Yulia has left a message saying that we can leave our questions, or you can leave your questions to me in the box.
Ben, thank you for a very interesting presentation. You have made a very compelling case for jury trials.
One with which you're quite familiar over the last 5 years, I fear.
That's right. So we have about 20 minutes left, and I want to once again invite the participants, the attendees of the seminar, to pose their questions. Meanwhile, I have a few questions of my own, if you allow me. I'll go first, since I don't see any questions from the participants yet. So, indeed, I know that you are a strong proponent of jury trials. We have spoken about it so many times during the coffee breaks at the ICC in between court sessions. The question I have, it might be a little cheeky, forgive me for that, but could you tell us actually your worst experience with jury trials, if you have had such?
Yes, my worst experience resulted in a Court of Appeal case where I had to argue that a jury decision was sound, should be respected, should not be overturned, when in fact I had distinct worries about it. I'll have to be brief. One of the notable cases that I prosecuted while I was still at the bar in England was the first case of modern slavery, which had been brought before the courts. The accused persons were all members of what we call the traveller community. It's a slightly politically delicate word, traveller. One certainly shouldn't want to use the word gypsy or Romany, but these were people who lived to a certain extent outside society and who didn't live in permanent fixed homes. And the allegation against them was that they had effectively kidnapped a number of people over many years and were forcing them to work for them. During the course of the jury's retirement, one of the jurors sent a note to the judge accusing another of the jurors of prejudice against travellers. And indeed, prejudice against travellers is something which is not uncommon in English society, I have to confess. And the judge had to decide how to deal with this allegation and made inquiries with other members of the jury who all, unsurprisingly perhaps, denied that they had expressed any such views or that they held any such views. One might think, well, of course they did. Nobody is going to admit that they're a racist. On that basis, pointing out that it was an unsubstantiated allegation made by one person and not backed up by any other members of the jury, the judge permitted the jury to continue with their deliberations, and they returned guilty verdicts. Not surprisingly, the defense appealed on a number of points, but on this point alone, not alone, on this point amongst others. And the Court of Appeal considered the matter, but ruled that they could not find on the evidence before them that the conviction was an unsafe one. So that's, I think, my worst experience, because it seemed to me that although it was an unsubstantiated allegation, it wasn't really surprising that it was unsubstantiated. And I had a concern, a sort of sneaking concern, a lurking concern, that there might be some truth in it, and that in fact the jury in that case might have been influenced by considerations other than the evidence.
Thanks, Ben. Now, the other question I have concerns Ukraine. Not that you know how Ukrainian jury system works, but
yes,
I will ask it in a way that I think I see a question, but I'll ask my question first, and then
yes.
I'll read it out to you later.
Yes.
So the question: Ukraine allows jury trials if two conditions are met. So first, it's
life imprisonment.
Indeed, life imprisonment, and the accused person requests, even if it's one person in a multi-person trial, there will still be a jury trial. Now, in your opinion, that's obviously a quite different system from what you have described, but in your opinion, is it too restrictive, or is it just about right?
Actually, I think that you and Ukraine may have it right better than we do. Jury trials are expensive and complicated to organize. Right now, in the middle of the COVID pandemic, perhaps the reason why we're speaking to each other on Zoom or rather than face-to-face, jury trials at my court, at Woolwich Crown Court, are operating at about 15 or 20% capacity, because the need for social distancing means that jury trials can't, the 8 jury trials we would normally have running at once, it's a big court centre, can't take place. Just too many people in too small spaces. And in England, a person is entitled to a jury trial not just for really serious matters, but for a whole host of matters. For example, theft from a shop. A persistent shoplifter, somebody who feeds their drug habit by stealing beer from a supermarket, is entitled to a jury trial every single time they do that. And in my opinion, that's not terribly helpful. I don't think that the wide availability of the jury system for repeat offenders is really the best use of the jury system. I think that we could be more selective. I think that the Ukrainian bar limit of saying it has to be only in cases where life imprisonment is a potential penalty might well be a good bar. I think I might myself pitch it a little lower, perhaps, where the potential sentence is no less than 15 years imprisonment. But no, I can see that actually the system you have in that respect is one which could well work better than the system in England and Wales at the moment. I think so far as the other aspect, the choice of the defendant, is concerned, it's a question of trust and confidence, isn't it? People in England choose jury trials people, accused persons in England, because they know that the conviction rate in jury trials is lower than when trials are judged by judges alone. Juries are more careful, if you like, are less willing to accept the words of police officers and of prosecutors than judges are. Juries are more reluctant to find people guilty than professional judges. And so, of course, people trusting accused persons, trusting that, or you could argue taking advantage of that, choose to be tried by a jury. The difficulty, as I understand it, is that jury trials are almost unknown, or at least very rare in Ukraine, so that persons who are on trial don't have any comparisons to make. They have no means of knowing, and they are, like all of us perhaps, a little scared of the unknown, and particularly perhaps also their lawyers are scared of unknown quantities, and so are reluctant to entrust their clients' liberty to an unknown quantity. So I would say that the precondition in the Ukraine is not a bad one. I don't know how to overcome the potential reluctance of accused persons and their lawyers to take part in jury trials without there being the long-established tradition of jury trials. I don't really have a solution to that one. Can I move straight on to the question from Thomas Hamill?
There are two questions, one from Thomas Hamilton and another one from Gayane Nurijanyan. Sure, Ben, you don't need my help with reading the question.
No, indeed, I don't think Thomas Hamilton. That's a rather English sounding name. That's Welsh. And Thomas Hamilton says, what do you think of the success or failure of non-jury trials in complex fraud cases in English courts? Do these cases support the use of judicial fact-finding in international crimes cases, which are often similarly complex, sometimes involve expert evidence of a technical nature? I don't think that complexity, either expert evidence or the large mass of facts, is something which militates towards trial by or fact-finding by judges. I think that there are means by which a jury trial can comprehend, a jury can comprehend complicated, voluminous and technical evidence. As I said a little earlier, the onus is on the advocates and on the judge to ensure that that evidence is broken down into comprehensible elements. And I think, in fact, that that discipline of breaking down complex evidence really helps, because, as I said to you at the beginning of my talk, the research suggests that judges aren't any better at understanding complex and technical expert evidence than ordinary lay people are. They may be or they may not be. The research tends to suggest that they may think they are, but in fact, they are deluding themselves. So I don't think that the use of judicial fact-finding in international cases is well argued for by the fact that such cases are typically complex, with voluminous evidence and involving expert evidence. But I do think that there's another reason why international criminal cases don't work well in a jury system. There's only so much you can ask of a jury. 2 weeks in a lifetime, that's a reasonable ask. And in very serious cases, cases may go on for more weeks, sometimes for months. But to ask a person to give up years of their lives. Yulia and I have just concluded a case. Well, actually, the case hasn't concluded yet. Case started in January 2017, the Dominic Ongwen case. Where are we now? August 2020. So we're 3 years and 8 months down the line, and there still isn't a verdict. I don't think that you can reasonably expect persons to give up a significant chunk of their working lives to be jurors. I don't think that is practical. And you would have to bring people from all over the world, from Uganda, from Peru, from Britain, from Australia, from Vietnam, to be part of a jury selection process. And they would then have to live for years away from their homes. You lose in that process, but such a jury would become itself professionalized. It would become habituated to the process, and you would lose the advantages which I spoke of real citizen participation. So I don't think that juries are a practical proposition in international criminal cases, but for a slightly different reason than the one which Thomas suggested. So I am moving to, I'm going to pronounce this horribly wrong, Yulia Nuzban, who says, since you've mentioned the ICC, what do you think about the suitability of procedures used in jury trials to the proceedings before the ICC? Okay, well, I've just dealt with that. In short, I don't think that jury trials are the way to go at the ICC. But Guyan goes on, I'm referring, for instance, to midway acquittals or declaring a mistrial, as the majority did in Ruto and Sang. I have to say that my own opinion is that the no case to answer procedure, which is completely unknown in the statute itself or in the rules of procedure and evidence, entirely invented by the judges, I think in the Ruto case, Yulia will correct me if I've got that wrong, by judges or by a presiding judge who had a strong common law bias. I don't think that that procedure works very well at the International Criminal Court. As I said to you when I was discussing it briefly in describing the system in England and Wales, the no case to answer submission essentially is useful where some part of the anticipated prosecution case has not emerged. A witness has failed to show up at all, or has recanted their evidence, or has been cross-examined in such a way that they admit that they've been telling lies or have been confused. In my opinion, where a panel of judges in the pre-trial chamber has decided that a particular universe of evidence is sufficient to establish that there are substantial grounds to believe that the crimes have been committed by the person accused, then unless some part of that evidence does not emerge, some significant part, I would say that at the ICC there should be no procedure of no case to answer. The no case to answer procedure is a kind of filter or test which is necessary in a common law system where there is no pre-trial procedure. Before the trial comes along, there is no testing by an investigative judge or by any other judicial body of the merits of the prosecution case. The first time it actually gets tested is at the trial. And so at the halfway point, when the prosecution actually presented its evidence, it is important that there is the possibility of bringing proceedings to a halt. So far as the ICC is concerned, with its mixed common law and civil law procedure, and with the pre-trial procedure, which is much more civil law based, I think that the no case to answer procedure is much less useful. And I am disappointed that the judges have embraced it in a rather, in my view, incoherent way, for example, in the Bagbo case. And I applaud applaud the judge in our case, the German judge, perhaps not surprisingly from a civil law system, who simply said to the defense, I don't want to hear any submissions that there is no case to answer, so that the question never raised its head. Halina Botcheva, my apologies again for my pronunciation, asks this. It's often said that the jury system is particularly vulnerable to trials by media, particularly in high-profile cases. Do you consider such fears are substantiated? If so, are there any ways to prevent trials by media in the age of social media? Yes, I do think that the jury system is particularly vulnerable to trial by media, and I think by that you must mean where there is enormous publicity, where people are speaking their opinions loudly and frequently on the television or on Facebook or on Twitter about whether the accused person is guilty or not. And I don't think you can avoid, in very high-profile cases, trials of prominent politicians or sportspersons, the jury having some knowledge of matters which have been aired on the television or in social media. We address this as judges head on. We tell the jury at the start of a trial, you will have heard, or you may have heard, matters which may be relevant to this trial before you came to this building. You need to be able to put those matters out of your mind. That is to say, you can't ignore them, but you need to be satisfied that you will be able to judge the defendant fairly on the evidence you hear in this courtroom. And if you're not satisfied of that, if you are concerned that you might be influenced one way or the other, then please say so, and you can stand down from the jury. As I said earlier, and I'll wrap up because I know that time is now coming to an end. My impression, and it can only be an impression, it's certainly not verifiable, and I can't even really claim it's objective, but my impression as somebody who has long experience of watching juries go about their business is they take it terrifically seriously. They are aware of their duty to do justice. They're very keen to do justice. They are excited and pleased to be taking part in this aspect of society. It makes them feel worthwhile and valued. And I think that jurors shouldn't be regarded as pawns or little boats blown around by the storms and winds which we lawyers with our better education are more able to withstand. Actually, I don't think that's the case. Sure, we're better educated. We can argue better how many angels can dance on the head of a pin. But are we actually any better at understanding and deciding the really important issues in life? Issues like, what did somebody intend when they did something? Issues like, was somebody under duress when they did something? Issues like, is somebody telling the truth? I don't think that my law degree, I confess it was a long time ago, I don't think my law degree qualifies me in any respect better than the man who fixes my fridge when it's broken, or the man who mends the roads, or the woman who runs the shop, or the lady doctor who treats me when I go to hospital. I don't think I'm better at these fundamental questions than they are. I'm a lawyer. I'm good at arguing that black is white. I think that is the end, or that's all the questions we have up, which is good because we're at 18:03 and time's up. Can I just say, although I haven't seen any of your faces apart from Yulia's, with which I'm well familiar, that it's been a real pleasure. And I see that 18 of you are still participating, which is roughly the number we started with. So I haven't managed to bore the pants off any of you. And I'm very pleased about that too. It's been a real pleasure, and thank you very much for listening.
Ben, thank you for finding the time to talk to us about jury trials on this Tuesday evening. I would also like to thank the attendees for finding that hour to listen to your presentation. And finally, I also want to thank the Ukrainian Bar Association for giving the platform for you to speak to the to all of us. I was very interested in what you had to say too, I must say, even though we've spoken about it extensively in the past. And on that note, that concludes the seminar.
Thank you very much, and I hope you all have a very good evening.